So without further ado, I'm Martha Ambrose. If you don't know me, I am the Executive Director of Cal-ISBOA, California Independent School Business Officers Association. I'm happy to be working with CAIS on this, and without further ado, I'm going to turn it over to Deb Dowling now to talk about just sort of some of the basic infrastructure of this morning.
Thank you, Martha. Hi, everyone. I'm Deb Dowling. I'm the Executive Director of CAIS, the California Association of Independent Schools. And Martha and I have partnered together to bring this webinar to you. We are recording the webinar because some people couldn't be here at 9 o'clock in the morning. And in addition to recording the webinar, we will also distribute the recording and the slides within the coming week, possibly with some other features as well, if we manage to pull some together. If you have questions during the webinar, please put them in the chat. And every now and then there will be a pause for questions, and Martha and I will read questions from the chat. We won't be able to get to everybody's questions, I'm afraid, because it's going to be a lot of people in a very short period of time. Martha, can you introduce our guests, please?
Certainly. It is my pleasure to introduce Nicole, Cam, and Jason Geller from Fisher Phillips. They'll give you a little bit of background on them. And just know that as we start this webinar, we know that this is not a topic that is that we're only going to address once. So moving forward, I'm sure we'll get more information, and Nicole and Jason may be able to kind of give us an idea of what's going to be clarified in the future. So Nicole and Jason, take it away.
Super. Well, Martha, thank you so much. And on behalf of Fisher Phillips, I want to thank Cal-ISBOA and CAIS for inviting Nicole and me to deliver this presentation on pay disparity and pay transparency in California. Before I begin, I will turn it over to Nicole to introduce herself, and then we will go ahead and begin the presentation.
Well, thank you so much. I hope everybody can see the presentation in front of you. I am Nicole. Wonderful. Thanks for the thumbs up. I'm Nicole Cam. I'm here with my partner, Jason Geller. He mentioned, we're from Fisher Phillips. I'm down in the Woodland Hills, LA office. Jason is up in Northern California, and we have offices throughout the country. We exclusively practice employment law representing employers primarily, and this is definitely a hot topic, as is an ever-changing landscape here in California, trying to be an employer in California. So we're happy to spend this hour with you and hope you take away some helpful information.
Super, and thanks, Nicole. And my name is Jason Geller. I manage the San Francisco office of Fisher Phillips. I'm a member, an active member of our firm's education practice group, in which I represent several private independent schools throughout California. And it's really my pleasure to be here and participate in this webinar. We're gonna talk about new pay transparency requirements for a guide for independent schools. And just to orient ourselves briefly about the agenda today, and I think as Martha mentioned, we do have quite a bit of material to cover. We're gonna do our best to address questions as they come. If for some reason we're unable to address all the questions, please feel free to leave them in the chat. Nicole and I can address the questions after the presentation. You will receive a copy of the deck as part of the presentation. So as just a high-level overview, we're going to cover SB 1162. Now, Governor Newsom signed a lot of laws that would apply to independent schools, or will apply to independent schools in the state of California. Today, we're only going to talk about one of those several laws. It seems that in California, legislation just continues to proliferate when it comes to certainly in the employment sphere that impacts independent schools, of course. Senate Bill 162, we'll talk about just briefly some of the pay data reporting obligations under this new bill. We're going to really focus on the pay transparency rules. And then we're going to talk a little bit about where we are currently, because this is nothing new. This is an amendment, a supplement to what we've been seeing already in California. So we'll talk briefly about existing law and then some related provisions of the labor code that we're all going to be interested in at least being reminded about, given the potential morale impacts that some of these, this new SB 1162 may lead to in our schools. We'll talk about pay transparency requirements, and then we do have a litany of common questions that we've been getting from schools already in the wake of this introduction of this law, and hopefully we're going to address the ones that are on your minds. If not, certainly put the new ones in the chat. We'll try to tackle them, and then we're going to wrap up with some discussion about some compliance and some practical guidance on how to deal with this new law. And with that, why don't we kick off with talking generally about SB Senate Bill 1162. And as I mentioned, there are two main components to this. There's this pay data reporting component for schools that have at least 100 or more employees. And then there's secondly, and the part that we're going to focus on, the pay transparency provisions that all have to do with job postings and pay scales and pay ranges and what do you have to give to somebody when they're applying for a position. And we're going to focus on the latter, as I mentioned. A thing to remember, this bill, unlike some of the other bills that Governor Newsom signed, does become effective January 1 of this year. So we're certainly going to want to get in front of it and be ready. Needless to say, the Division of Labor Standards Enforcement has not yet rolled out its FAQs, even though compliance is on the horizon. More about that later. But this is a new law that comes into effect immediately. So we want to get in front of it. The other thing I would just say generally is that this statute is part of a theme we've all been seeing in California, maybe in beginning with the Me Too movement and afterwards, concerning pay discrimination, sex discrimination in employment. But that's something that the legislature perceives to be a problem in California, and the laws have followed. And this is a poster child of that type of legislation to ferret out potential discrimination, both based on sex and here race and ethnicity, mainly in compensation. The other part of this, I just want to say as a theme, is that it deals a lot with disclosure. That's something you've seen among a lot of the new laws that have come out in California, where the legislature wants to allow employees and applicants to be free, to feel free to express their views, to ask questions, and to require more transparency on the part of employers. So including schools, of course, in their employment practices. So this is part and parcel of that. And with that kind of backdrop in mind, let's dig in a little bit more on Senate Bill 1162. As I mentioned, we are going to be addressing the detailed pay data reporting provisions under this law. I saw in the chat, some folks were saying we already are EEO1 reporters. We have more than 100 employees. This, perhaps they were suggesting, won't be that big of a deal. I hope it isn't. And that's correct, that this law, the reporting provision of the law, and I'm just going to touch on this at a very high level, does apply to schools that have 100 or more employees. Now, one of the big changes here, and in my experience, many of my clients don't rely on staffing firms that often, but if you're using a labor contractor, which includes a staffing firm, those employees will be included in getting you potentially to the 100 employee threshold for reporting purposes. And then this new reporting provision definitely is going to expand our obligations to report data to the California Department of Civil Rights. Now, one thing I want to mention briefly about that is that fortunately, this isn't going to be emblazoned on some public website for everybody to see. Oh, what is ABC school paying its faculty? And I want to go look and make my comparisons and tee up a potential lawsuit or something. Okay. It's not going to be publicly available. That was a push, but fortunately, folks on the employer side of it were able to keep it private, so to speak. But it is going to be reported to this public agency, the California Civil Rights Department. There are going to be some civil penalties. I mentioned, of course, they're very concerned about enforcement. So when the time comes to get in front of this law and get your reporting data expanded and ready, note that there will be potential civil violations. The other thing, because the time to comply is on the horizon, May 10th of next year, the reporting requirements currently are in March. It's going to be moved to the second Wednesday of May thereafter, starting next year. May comes here before we know it. So we certainly want to be very prepared to comply with the paid data reporting provisions. As I said, we're going to address this in a detailed webinar shortly, so I'm not going to get into the weeds, but I want everybody to have this on your radar if you are an EEO1 reporting school or you think that you may be come next year. And again, this was an expansion of Senate Bills 973 that already required some of this data to be reported.
Jason, can I interrupt for a sec? Because I know there's a lot of people wondering if they can ignore this part of it because they have either a lot less than 100 employees, or else they only get up to 100 if they encounter in their like seasonal employees. So can you address who can ignore this part of it?
Certainly, and Deb, thanks for the question. And yes, if you're a school that is well below, and I would say several of my clients are well under 100 employees, then you won't have to be concerned about the paid data reporting aspect of it. But if you are abutting against that 100 employee threshold, or you think that you're going to get there, then I think you're going to want to be conservative and plan for it. Now, I have some clients that say, we're just going to 99 and we're going to do everything we can to stay underneath it. That would be fine. But yes, if you're under 100, you can tune out. Okay, good question, Deb. Let's see. Why don't we move then to the next slide on pay scale, and then I'm going to turn it over to Nicole to address pay scale and what the heck that means. Nicole, do you want to take it over from here?
Yeah, thank you, Jason. I'm just going to give a little bit more background on what we're going to be spending the majority of today speaking of, and that's the pay scale, pay transparency requirements. This is part of a growing trend among state and local legislation that require different types of disclosures, documentation, and California, as we all know, is usually at the forefront of these changes. But in this case, there's actually quite a few other states that already have either state or local requirements in place. So if you are strictly California based, you're located in California, all of your employees are located in California, that is something that you're going to have to listen to what we're talking about, obviously, with regard to the California statute. But if you happen to have employees working in other states, locations in other states, if you do business in other states, we need to be thinking about the other state requirements as well. Some of the state requirements like Connecticut or Nevada are less stringent. Other ones have different types of requirements. So you'll see we kind of have broken this down into a chart. And if you do have any of these areas on your radar, then we can certainly assist further with that. But this actually gives us a little bit of insight because, as Jason mentioned, we don't have guidance further than the statutory language as of today. We should be getting that hopefully soon, hopefully by the end of the year. But until then, we can kind of look at other state statutes and how they're interpreted and think about how that might apply in California. Since this is something that affects many of our clients nationwide, we've put together a pay equity interactive map. If you do need to look at the different laws in other states, you're welcome to visit our map, which is at this location, and we can certainly answer any other questions that might come up with that. But nearly every state has laws to essentially complement the federal Equal Pay Act. So equal pay for equal work, regardless of any protected category, is something that we're also going to be touching on today. So Jason, you want to talk a little bit more about what's currently in place?
Yes, absolutely, Nicole. And just one point about the slide about other states, and we're going to talk about this because certainly the majority of our audience are California-based schools. The question, and this is a little teaser, will be, well, what if we are recruiting nationwide for a position in California? You're looking for a new head, and that can be certainly, we know, a nationwide search. That's a good point that Nicole mentions, that if you're in that position and you're recruiting outside of California, you are going to certainly want to know if there is any kind of local requirement, meaning a state requirement outside of California that potentially is applicable by virtue of where you're recruiting from. And given that these laws are very fresh, and like a lot of the other states, I would imagine, like California, they're just school employers are trying to navigate what a lot of the language means. There's going to be a lot of uncertainty, but you got to spot that issue. And I've seen that often. I have several clients that recruit all over the country for heads, for example, and we're gonna need to know what's happening across the land.
Jason, I'm getting some more "does this apply to me" questions. Firstly, are we now in the zone which is for people with 15 or more, or are we still in the zone for 100 or more?
So very good question. And we are getting into the 15 or more zone. So
great. And the next question is for the stuff that previously was on the 100 or more. Does that list of employees include part-time employees, and does it include seasonal or temporary employees?
The answer is it's going to include part-time employees, seasonal employees. It's going to depend on how long they are employed. And I would need to double check that time period for the reporting trigger for seasonals, but it will include part-timers for sure.
Thank you. So now we're back in the 15 or more, which should apply to everybody. So thank you.
And I'll even mention that there's even if you're under 15, if you're a teeny tiny school out there, there's requirements for you as well. So now's the time to kind of clue in.
Yeah, this is the time to wake up. We've all been tuning Jason out. I understand, Nicole, you're probably riveted with what she's saying. But yeah, this now we are changing gears, and we're really going to focus on job postings, pay scale disclosure. What do we have to say? What do we have to say to applicants and current employees who are applying or receiving postings? This is where we're headed now, and this is what we're going to focus on for the primarily for the remainder of the presentation. And thank you, Deb, for underscoring that transition. And what I want to talk about right now briefly is just a reminder of where we've been, and then obviously we're talking about where we're going. So what does current California law say when it comes to salary ranges, pay scale, and the disclosure of that stuff? So I mentioned Labor Code Section 432.3. That's the law that is being amended by Senate Bill 1162, and that's what we're discussing today. This is part of what we know, and Nicole alluded to this, is the California Equal Pay Act. It's also under, if anybody's interested, Labor Code Section 1197.5. And basically that statute and 432.3, they're all concerned, it's all concerned about ensuring that pay is done without regard to, pay decisions are made without regard to not only sex, but in California, race and ethnicity. On the federal level, we've had that Equal Pay Act for a long time. Most people know that's the sex discrimination in pay law that says you have to pay men and women the same for substantially similar work. California's version is the Equal Pay Act, the California Equal Pay Act. It's expanded on the federal law to include race and ethnicity. And so this whole deal about pay transparency and disclosure of pay scale, as I said at the beginning of the presentation, it's all intended to prohibit discrimination or discourage discrimination in pay based on sex, race, and ethnicity. So under 432.3 currently, we can never ask an applicant about salary history. I think most of us probably know that already, but I think it's just worth reiterating. You can ask about salary expectations, and this isn't changing. This is the law. It's going to be the way it is for the future, I'm sure. It's never going to change. But you can ask about salary expectations. Now, if somebody volunteers their salary history to you during the job interview process, okay, there's nothing preventing you then from considering it. But the key is to avoid eliciting any disclosure of, or eliciting any disclosure of the salary history, because that can get you into trouble. Now, many of my clients who are hiring teachers, faculty from public schools, I'm sure we all know about California transparency, where if I want to go online and look at the salaries for public school teachers, I can find them. In fact, I was discussing this with an education colleague last night. So there's nothing prohibiting an employer, an independent school employer, from looking at publicly available information. You just can't ask the applicant about salary history. And then here under current law, it currently only applies to applicants here, right? We're going to talk about current employees in a minute, but under this law as it stands, if an applicant makes a reasonable request, you don't have to volunteer it, but if they make it, then you got to tell them what the pay scale is for the position for which that person is applying. And pay scale, much like it means under the amendments, salary or hourly wage ranges that we reasonably expect to pay. More about that in a minute. And as I say here, reasonable request, that just means at least under current law, anytime an applicant might ask for it after the initial interview. That's what the FAQs by the Labor Commissioner have explained what reasonable request means. Now that's all changing, as we're going to talk about here in a moment. The last thing I want to mention about this law, not surprisingly, is that individuals who claim that the law has been violated are permitted to sue their school employer or prospective employer for violating these laws. So again, every law, it seems, that in California gets legislated includes an inducement, and forgive my editorialism, I am a defense attorney, I represent schools. It is an inducement to litigation. So we really want to make sure we are buttoned up on this stuff. Now, if we shift to the next slide.
Oh, yeah, I'm sorry, I just wanted to add one thing that I get asked a lot is this prohibition, this restriction on asking for salary history. It applies not just to the school, but if the school is using a recruiter or a staffing company, you cannot try to solicit that information either personally or through an agent or third party. So just wanted to put that out as a flag.
Nicole, very good point, right? Because the statute says it prohibits an oral or written request for salary history whether it's done indirectly or directly. Very good point. So still sticking on current law, folks, and I just want to give a backdrop on this because it's, I think more issues are going to be provoked given this, the salary transparency rules that we're discussing. Current law under 232 of the Labor Code, it says that we cannot punish employees for disclosing their own compensation. I can't tell you how many times I've seen because I review student and parent handbooks, and I review employee handbooks all the time. It's mainly on the employee side. I might see a school that has a provision that says don't discuss your salary. That's private. That's actually illegal under California law. And I'm also a litigator, so unfortunately I have to defend schools if they get into court. And fortunately, I haven't had to defend a school on this, but I've defended other private employers who have allegedly punished employees for disclosing their compensation to their colleagues. And that's something that is encouraged in California. Again, we talked at the beginning, it's a theme here that everything needs to be laid out there so people can share information about their compensation as well as their working conditions. So a companion to 232 is this other section on the slide that talks about working conditions. And that's broader. That goes beyond compensation. I'm not going to spend much time on it. I just want to let you know that it's a protected activity in California, meaning if you have an employee who is complaining about, let's say, any conditions on campus, any type of working condition, arguably raising concerns, that's something that they're protected to do. And so from which employers, independent schools cannot punish them. So it's just something to just bear in mind. We're expecting a lot more activity in this area, given the changes to these bills. So now I'm going to turn it over to Nicole to talk about the new changes to these laws made by Senate Bill 1162.
Nicole, at what point, you can tell me that you're going to get to this later, but in the hiring process, at what point do you have to honor a request for the salary range? Is it if somebody applies, if somebody is interviewed? Is there clarification on that?
Yeah, and we actually are going to get to that. So I'll just put that on hold. And if we are going to get to that. And thank you for bringing that question to our attention. We'll kind of cover that because it's a little bit different than it was before, right? Before it was after the interview. Now it's it's going to be kind of a different process.
Okay. So that's a change.
Okay. So now talking about what we're facing heading into 2023. So effective January 1, 2023, we have that prior law, Labor Code 432.3, amended. And the first amendment, as it applies to current employees, is that if you remember in the past, it only applied to applicants and it expressly carved out current employees. Now the statute will say, an employer on request shall provide the pay scale for the position in which the employee is currently employed. And this is one of those points that applies to employers of all sizes. So again, this is current employees who on request ask for information about the pay scale for the position in which they're currently employed. So some of the questions that have come up, and I think this is one of our FAQs, but can they ask about other positions? Can they ask about other types of roles in the school? And as the language currently reads, it's the position in which the employee is currently employed. So that's how we're interpreting it as of today. If we get any further guidance, we will certainly revise that, but that's our understanding. So now current employees are entitled to this information on request. Now, part two, which is where the 15 or more employees come into play, is job postings. So we're talking about applicants, we're talking about people transitioning over. And this requirement is that an employer with 15 or more employees shall include the pay scale for the position in any job posting. And there's been debate on that. We're going to talk about that a little bit more. But any job posting, in my view, is a pretty broad term to use. So we're gonna hit on that a little bit more. But basically, 15 or more employees include the pay scale in any job posting. That also applies similar to the point I raised earlier, that if an employer is using a third party, an online resource, a recruiter, anything outside of themselves to seek an applicant, that the third party also has to announce, publish, post, or otherwise make known that pay scale, and that the employer has the obligation to let the third party know, and the third party must then include the pay scale in the job posting. So this is a communication that's going to have to take place. And I would really have the employer double check that any of its postings include this information, again, even if you're outsourcing it to a third party.
Nicole,
And then,
I was
go
gonna
ahead.
just add one quick point on that. If you're using a recruiter, you want to really take a look at, obviously, their practices in this regard. And you might also look at your agreements that you have with the recruiters, both in terms of there, God forbid, is any litigation or disputes, who's going to be responsible for that. In California, employers that use, for example, staffing agencies are jointly liable for wage and hour violations of the staffing agencies. So this is something that if you're delegating it, you want to understand who's managing, who's got the risk, who's bearing the risk of claims.
Exactly. No, very good point. And then part 3 of this statute with regard to applicants. So this is in addition to the job posting requirement. There's a requirement for employers of all sizes to provide the pay scale for a position to an applicant on request. And this is different because in the past we had talked about after completion of an initial interview. Now that's no longer, it's at any time on request. So practically, this might not come up because most applicants will have seen this in the job posting. So you will already have met that requirement. But remember, that job posting requirement is for 15 plus. This applies to all sizes of employers. So let's say there's not a job posting, maybe it was a referral, you contacted that person directly, there's not that job posting, so they might not have this information. Any applicant on request is entitled to this information. So this is just another point to keep in mind as you're going through the process.
Can I just ask again about posting the pay range, pay scale? There was actually a very applicable question in here. So does that mean that positions that are posted on the CAIS website and the Cal-ISBOA website will need to have that information starting January?
Very good point. Yes. Yeah, that was actually one of our FAQs too, but our position is that yes, if it's still an active posting as of January 1, it needs to include that information on a going forward basis.
And
So Jason,
go ahead, Nicole, sorry.
No, it's your turn. Go ahead.
Okay. I was just going to say, I've seen several great questions pop up in the chat. And one was, is this effective January 1 of 2023? The answer is yes. So just to make sure there's no confusion over that, this bill becomes law January 1, 2023. The part that's a little delayed is that pay reporting provision, right? You got to report your data if you're covered, you're 100 or more employees. If you're covered, you got to report your data by May 10 of 2023. But this job posting stuff that we're talking about right now goes into effect January 1st. Happy New Year. So, would this be a good time, Deb, to pause? Are there any other questions that we should address, or should we keep proceeding?
I think there's a lot of curiosity about what a pay scale will look like. And that includes, does it have an upper limit that the school cannot go over? Does it, like, how wide can the range be? Can you separate it out by experience levels, those sorts of things? So there's a lot of curiosity about what it actually looks like.
Perfect. And that does anticipate a few of our softball FAQs that we built into the presentation. So I'll save a little bit of that for in a few minutes, but let me go ahead and address some of it now on pay scale. I mentioned the reasonably expects to pay. So this law does not define what that means. No surprise. And a lot of the questions that Deb just mentioned also are not defined in the law. It's a very it's very similar to a lot of the legislation that we have to deal with. It's pretty vague and broadly defined. But what's important here is this reasonably expects deal. That is an objective standard. Whenever lawyers see that in a law, reasonably, that means that you got to have facts to support your pay scale. So what would those facts conceivably be? Well, and this is something that actually I should mention came up in our discussion with Martha a little bit before the presentation. There was an article in the Wall Street Journal on last Tuesday about New York's pay transparency rule, and employers are putting pay ranges from 0 to 10 million. Well, that doesn't really do much for an applicant, right? I'm facetious, but you know what I mean. Broad ranges. And the problem where an employer might come into a problem, have an issue there, is if the school doesn't have any factual basis to show that this was a range we were anticipating. So you're going to want to think about that. And I think some factors would be, what has been our history of paying for this particular head position or faculty position or admin position? What have we paid typically in the last few years? Now, it can always change, but that's going to be a data point. Are we relying on salary surveys, for example, to drive our pay scale? That is something that might go to, what did the school reasonably expect to pay for the position? So we want to have, and we want to have something to point to if, God forbid, we're ever challenged on that issue. Similarly, and we're going to talk about this, negotiations. When you post something and you negotiate that pay scale for somebody, how does that fit within the reasonable expectation of the pay range for subsequent job postings? So it's really got to be something you can point to that you realistically intend to pay. I know that probably isn't the crisp, bright line rules that everybody is looking for. Unfortunately, we just don't have those right now. And the law injected this reasonable standard in there to make it a little bit fuzzier. If we could go to the
Jason, does it have to be from this number to this number, or can it be a link to a grid with, different levels of experience and things like that?
Well, there wouldn't be anything prohibiting a school employer from giving that kind of detail. I can think of some risk management reasons for which you wouldn't want to have that link, but we can certainly talk about that a little bit further when we get to some of the FAQs. I mean, and again, I mean, I'm a defense attorney. I represent schools in litigation and in counseling to mitigate risk. The more information that a school discloses, well, it might help us, but it also might hurt us if somebody is potentially looking for a challenge on our pay practices. So on record keeping, I just got to, I mean, the slide says what it says. It's, the couple practical tips on this. And fortunately, knock on wood, most of my school clients have not been the targets of widespread wage and hour litigation. But if you're ever a target for a claim, let's say for alleged unpaid overtime, or somebody didn't get their meal period on time, or a rest break or something of that nature, you're going to want to hang on to these records for at least 4 years post termination. And I have a lot of I tell a lot of clients, hang on to your employment records for up to 7 years in general, because the legislature has expanded the statutes of limitation. That just means the time in which somebody is required to file a lawsuit or else lose that right. They've expanded that time period. So you might not think I'm going to need these records in 4 or 5 years. And in fact, I actually need them now. And gosh, I wish I didn't burn them. So anyway, that's just one piece. The other thing I'll say about this old rebuttable presumption, a theme in California, if the company or the school or the nonprofit or whatever your employment environment is, does not have adequate records, it creates, you're digging yourself out of a hole. And so if somebody were to come back and God forbid sue the school for a violation of the Equal Pay Act, and they're looking for compensation records and pay scale data, and you don't have that, well, you're digging yourself out of a hole to try to prove that the pay scale or the pay range was actually different than what the plaintiff is claiming. And it actually creates a presumption, meaning that the school is guilty until it proves itself innocent, basically is what this means. So we really want to be mindful of record keeping. And I run into, unfortunately, a lot of problems with record keeping and representing not only schools, but also other employers too. So it's really important that we comply with this. Now, enforcement, no surprise, big scary numbers. Just the one thing I want to mention here is this civil action. So what that means is that, yes, if there is a violation, somebody can, an alleged violation, somebody can sue the school to enforce this law. And I was recently on a panel with some employee side attorneys. We only represent schools and management employers in workplace law matters. We don't represent workers. But I was on a panel where some folks on the other side of the fence were presenting, and they're bringing a lot more of this alleged equal pay violation litigation. And I don't think you have to be a mega national company to be a target of this stuff. In my experience in defending litigation, employees are asserting their rights more and more in this area. I've got 3 or 4 of them going on right now. So I think it's a call to action that we want to update our practices and mitigate our risk.
Jason,
Yes.
just a couple clarifications, I guess, for people on the record keeping aspect of this. We're still talking about employees with 15 or more, employers with 15 or more. So essentially everyone.
Correct. Essentially everyone. And thank you for that clarification. Again, we're talking about smaller schools now that have to deal with compliance here. This section all has to do with 432.3, which deals with the pay transparency requirements. It's not the pay data reporting that we were talking about earlier. That'll be the subject of another presentation.
And another thing related to record keeping, I guess the question is this is for going forward. What about retroactively? I think people are concerned if they're asked pre,
Yes.
for information pre-1-1.
That's a very good question. And my advice would be, Nicole, correct me if I'm wrong, this law does not have an express term that says it shall apply retroactively. At least the amendments do not.
Correct.
Nicole, let me know if I'm wrong on that, but I'm pretty sure I'm right.
Correct. Yeah, this is a January 1, 2023 forward.
Right. So, although sometimes laws will expressly say you got to do a look back, or there might be a judge-made decision that says the law always applied. Thank you. That happens far too often, unfortunately. This does not. Nevertheless, the practical advice is keep your stuff, keep it preserved, because you may need it later.
Great.
Any other questions on record keeping, Deb or Martha, that jumped out? The exciting topic of record keeping.
This is not a record keeping question, but it came up repeatedly when you were talking about pay ranges. And that is, what if you post a pay range and then you end up paying someone more than that? What are the risks associated with paying someone more than the range you posted?
That is actually one of our commonly asked questions. I guess, Nicole, do you want to hit it, or do you want me to hit it now? We might as well.
Why don't you touch on it and then we can follow up?
Sure. So the risk, I shouldn't say the risk. I mean, look, you got to run your school. You got to get the right person for the job. We're not telling you to not exceed the scale. If you exceed the scale, there's nothing in this law that prohibits you from doing it. However, as I said, we came back to that slide, reasonably expects. That's got to be a legitimate expectation as of the time of the posting. It can change. There's nothing preventing you from doing it. The down, if you want to call it a downside, and we lawyers always look at the downside of everything. We're glass half empty kind of people. That, I guess I should speak for myself, but that could be evidence in the future of what is a realistic job, a pay scale for that same position when you post it later. So you are arguably expanding the pay scale for subsequent postings. I would say that's the biggest downside to it. I would say the other downside, since Deb asked about that, is that if you were ever challenged on it later, could somebody say, well, the school was fibbing and really wasn't being straightforward with this in the posting? They deviated wildly from the posting, and they might take a swipe at it. But I wouldn't necessarily worry about that as much. I think it's more of setting a floor for subsequent postings.
I agree with you, Jason. That's what I was thinking, is you're kind of on a going forward basis, you're expanding the range. And if you're going to go outside of that posted range, then you're going to want to be able to back it up with those, legitimate reasons that are not tied to sex, race, or ethnicity. So skills, experience, credential, whatever that person brings to the table, you're going to want to have documented that internally, so that if somebody does question, you're going to be able to defend that by saying, these are the objective, legitimate business reasons that we leaned on to give that pay that's outside of the projected range.
And then once an existing employee asks for the paid range associated with their job, if another person who has that job in the school is getting paid this extra super amount, now you have to adjust the pay range to include that, right?
That's correct, Deb. That's what I was suggesting, that once you deviate, you go above it, the next time you post that head position, or that's probably not going to be a head position, but some other position, let's say, that gets more frequently posted, you're going to have to likely adjust the pay range. Now, not necessarily if, let's say, the climate has changed, the school isn't as, the coffers aren't as full, the endowment has gone down, whatever it is, you've decided that you're going to pay a lower range. You can do that. But the point is, if you're ever challenged, somebody might come back and say, well, you paid this person significantly more. Why have you suddenly reasonably expected to downwardly adjust the range? Does that make sense, Deb? And the other thing, I just to add on to Nicole's very good point about pay equity, part of mitigating our risk, and we're not, unfortunately here to talk a lot about pay disparity, pay equity litigation. Unfortunately, there's more and more of it, but it is a risk that if you're deviating from objective, sort of stated criteria and ranges to make an isolated decision, you want to make sure, like Nicole said, you can defend it, defend the reason by using legitimate job-related criteria for which you paid that person a significantly higher salary. And remember, it cannot be salary history, or you can't ask about salary history. And even if they volunteer that, that can lead to a problem under the Equal Pay Act for pay disparity purposes, because part of the essence of that law is to discourage subsequent employers from inheriting or readopting previous alleged discriminatory pay practices from the old employer, right? So if the old employer was paying Jason a lot more money because he was male, and then he comes to work at ABC school as the new head, and if that's the only reason we're paying Jason more money because of his salary history, we can run into problems under the Equal Pay Act. So we don't unfortunately have time to get into a lot of that in detail, but to Nicole's point, we want to make sure we have legitimate criteria for pay differences.
Okay, so this is related in the what is included in pay. There are a number of questions very specific to schools. So what about stipends? Do you have to disclose stipends? Or if you're hiring a third grade faculty member, let's say, you're just saying this is what the pay is, this is what the scale is for teaching duties, and then, you know, how do you handle some of these supplemental things in addition to a relocation or a signing bonus? We have seen signing bonuses these days. Not strictly salary or wage.
Additional benefit, perk, incentive. Yeah, that's actually one of our upcoming questions. So maybe we'll head into those. And just pointing out again that the Labor Commissioner has not issued its FAQs yet. We're hoping by year end that will give us a lot more information. We're happy to share, if that does come out, that link to with Martha and your team and Deb and the team, and you guys can then pass that on to the audience. Okay, so some of our own personal FAQs that we've already talked a lot about, but we're going to hit again because they're very common. Does the job posting requirement apply if we have 15 or more employees in California or nationwide? And again, maybe this doesn't apply to a lot of the people on this call because maybe you're strictly California based. But if you do have employees outside of California and you're on that kind of that threshold, the way that the statute does not specify based on the statutory language, but what we're understanding that's consistent with how other California laws are interpreted is that it will apply if there are 15 employees nationwide. So if you have 10 in California and 5 in New York, you would then be covered by this requirement. Something to keep in mind if that does apply to you. Does this only apply to jobs based in California? What about remote work? Very, very common question. Now we're in this whole new environment of post-COVID remote work. You know, so much of what we didn't even have to question or consider a couple of years ago is extremely relevant now. What's important to keep in mind here is that some of the other state and local requirements, some of their ordinance that are in place in Colorado, New York City, specifically say that those pay disclosure requirements apply in even remote roles. So our California statute doesn't say that, but what we're recommending at this time is that if the position is based in California, or if it can be performed remotely in California, then the posting should comply with the pay scale disclosure requirement. Another thing that, you know, that I think is kind of telling is that language of the pay scale disclosure has to be included in any job posting. So, you know, depending on how you interpret that word, basically, if you're a covered employer, the 15 or more employees nationwide, our recommendation is to include the pay scale in the job posting.
Nicole, one thing I would add that unfortunately, I mean, for most of our clients, distance learning is in the rear view mirror, knock on wood. But if you still have somebody who is teaching remotely, or you have some employee in the administration who's working remotely, I know those are few and far between in my experience now anyway, you definitely want to look also at local ordinances because cities are beginning to legislate more in these areas, and I'd be remiss to not mention that you want to double check anything local that might apply to me in my area where my school is. Do I need to comply with it?
Absolutely. And that kind of ties into this next question of, can we define the job such that it cannot be performed in California or remotely from California? So the reason that I say this ties into other requirements outside of California is the Colorado statute specifically says that a declaration that the preference of the company is not to hire somebody from Colorado or working in Colorado does not eliminate that pay disclosure duty. So they're trying to kind of preempt that of trying to work around the system by saying we're not trying to exclude our own residents by having this extra layer of requirement in place. California does not specifically talk to that now. Again, may not be as relevant in this case. It's possible, but because of the audience here, it's probably going to be less likely. And again, you know, by erring on the side of caution and including that information in the job posting, you're kind of eliminating, at least you're mitigating that potential risk. So you kind of have to weigh the cost benefit of trying to go around that requirement.
And I'll take a couple of these FAQs. So this one, I mean, certainly it's more than likely not going to apply, as Nicole mentioned, to most of the schools in our audience that we're not hiring nationwide. However, if you, and so under the current law, you know, we would suggest that if you are targeting candidates from other jurisdictions or other states, that you be mindful of what those other states might say on these salary transparency requirements. And we will get on to Martha's question on what is total compensation. I know, for example, heads, a lot of the head contracts I've dealt with, they have housing allowances and relocation expenses and other kinds of perks, entertainment expenses and the like. So we'll touch on that, but I was going to say that some different states define the total compensation to be disclosed differently. And so if you are targeting candidates outside of California, if there's any chance that you think, well, my recruiting efforts might trigger the applicability of some other state law, then we want to follow that for sure and have an understanding of what those requirements are. Like I said, some
Jason, this would mean if you, I mean, how far do you have to take that? Like, okay, so we talked about our job posting boards. Okay, so our job posting boards are California-based associations. But if you're posting nationally,
if you're posting, so that's a great question, Nicole. Do you want to tackle that, or you want me to address it?
You go ahead, and then I'll add anything if I can think of an additional comment.
Yeah, I think it's this is where it's quite vague, right? I mean, I think if you're targeting a national audience, and arguably you're going to be considering candidates from right now, there are only 3 or 4 states that have these laws, but it might proliferate. You might want to be conservative and just say, I'm going to list the at least the California requirement. We'll get to that about what is a reasonably expected wage or salary, and just bite the bullet and put it in there, because you just don't know if this is going to have a target, if it's going to be targeted to a state that doesn't have a pay disparity law. I mean, I think my advice at this point, short of getting the guidance that we're all waiting on from the labor commissioner, is that if you're recruiting nationally, at least comply with the California disclosure requirements. Whether you choose to focus on and be more robust, like in New York or some of these other states that broadly define total compensation, that might be overly cautious in my book. I think you can comply with California and be okay. That's my view. Martha, does that help at all?
Yeah, I just think, you know, these are the types of things that we would just not think about, like if we're posting on NAIS. But I think when I'm looking at I'm trying to be mindful of time. And I don't want to cut this off, so I'm not cutting it off, but I know that there are tons of questions around pay scale. And years of experience and sort of how broadly we can make it. So can you just, you know, I guess the question would be, do you have to post your salary, let's say by years of experience, if that's how you look at your faculty pay? Or could you post the whole range from 0 to 26 plus and call that your range?
Nicole, do you want to tackle that or shall I? Did we lose Nicole? Okay. So, well, first of all, the law does not require, it doesn't apply only to high level or low level positions. So there's no distinction. So if you're posting for any particular position, you need to include the pay range for that particular position. And let's see, I apologize, but it looks like we've lost Nicole.
I'm so sorry. I'm back. If you can hear me, my laptop died, so I'm back on my desktop. But let me try and get I'm so sorry.
Okay, no problem.
So basically, it's if you're looking at it by years of experience, that's what you should post. Is that what you're saying?
Yes. If I understand your question correctly, that's right.
And can you say the pay range for this will be between $50,000 and $150,000 depending on experience? And is that enough, or do you have to say the specifics?
I would leave out any reference to the job related criteria you're going to use. I would just say we're posting for a faculty position or a TK position, in the ranges between $50,000 and $75,000, and just leave it at that. You behind the scenes as the school would be considering, that's a legitimate reason for making a salary determination, the level of experience of that individual. If we could go to the next slide, Nicole, and everybody, we will be able to wrap up here in the next 5 minutes. And then, as I said, we're happy to address any questions after the webinar. We want to be respectful of time. What is a job posting, and what about internal postings? There isn't any definition of what a posting is. So our guidance for schools right now is that if you're posting it internally or externally, these requirements would apply. So if you're posting it only internally for a faculty position or some other administrative position, what have you, and it's not being posted externally, still include the salary range or the hourly range for that position. Next slide, please.
Okay, so we had touched on this earlier, that if there's a job posting that was listed prior to January 1, well, we need to repost with the required pay scale information. And yes, we do advise doing that for any postings that are still active. Might be an opportunity to go through and take down any positions that have been filled. And for any current open positions, you can go ahead and update. For the pay scale information, do we need to list base pay only, or do we need to list incentive pay? Now, Jason, did you hit on this while I jumped off?
Generally, yes. I mean, it's wage, salary and base pay is what it says.
Yeah.
It doesn't say that you need to include a housing allowance, benefits, other forms of compensation.
Agreed.
We would not have to include stipends because they get a stipend for other duties. Is that the thinking?
So it's not required, but another kind of consideration is, what is the business answer? So what's the legal answer? It's not required. The business answer might be that, to be competitive, to attract the most qualified candidates, you do want to give that information about what the other perks, the incentives are. Or you could do something like, this is the pay scale plus incentives or plus additional benefits, so, and then you can explain further during showing that there's an opportunity to earn more, but maybe not going into specifics in the job posting.
I agree with that.
Okay. Does it have to be a range? Can we just list the minimum pay or the maximum? So it must be a range. You don't want to have something that says something like 30,000 and up or up to 60,000. You do want to have kind of a lower and a top number. But that range, as we've talked about, is, it is something to give more thought to.
And then in terms of flexibility, we talked about reasonable expectations. I won't repeat what I mentioned earlier about that. You want to have objective facts to justify the range, but it's up to you as the school to decide what you anticipate paying for that position. Next slide, please. And as I alluded to earlier, no, you are not stuck with the range. There are pros and cons. Deb asked that question earlier, and I think I addressed that. It might impact subsequent determinations of the pay scale, but currently, if you can justify it and mitigate your risk of a pay equity claim, it's fine to deviate. I'm not recommending that necessarily, but you're not stuck. And then let's see, we have the next slide. Nicole, I'll turn that over to you.
Okay, so we had mentioned this also for requests by current employees. Can they request pay scale information for all positions or just their current position? And the legal requirement is just the position in which they're currently employed. They're not entitled to all information for all positions. In terms of the penalty, Jason had spoken on this a bit. We currently don't have much guidance. There is language in the statute that says that the penalty is based on, a totality of the circumstances, that there is some leeway given for employers that kind of quote unquote cure a first violation. So you do want to make sure that you are reviewing this, that you're taking proactive steps to comply, and certainly reach out if there's any questions about specific changes that need to be made.
And go ahead, Nicole.
Oh, no, go ahead and wrap it up. I think you're the
I was
next
just
couple.
going to wrap up on this. Scary PAGA, basically, this is that penalty statute that a lot of employees have relied on. It kind of works like a class action. And really right now, it's not clear whether an employee could rely on the PAGA law to enforce this. My sense is that it's probably going to be allowed, but right now this bill does not expressly say PAGA does not apply. So when it's in its absence, I interpret that to mean theoretically it may be possible. And then just a few general comments on the next steps. First of all, certainly we want to know what laws we're dealing with, and we want to really assess what pay ranges we're going to use and why we're using those pay ranges, focusing on the objective factors that I mentioned earlier. And I think this was something that came up in our pre-discussion about job posting templates, understanding what is that going to look like, start preparing those now so you know what to post when it's time to point and click, as they say. On the next slide, I talk about a little bit about training and guidance. Now pay equity audits, if we can go to the final slide, we don't obviously have time to get into this, but I just want to say, you got to ask yourself, should we do one or shouldn't we do it? The thing about pay equity audits are that it can really help see if you kick the tires. Maybe I've got some exposure. Maybe I have some problems here. Try to work, and this isn't a school lawyer's employment act, but I do want to say that you want to protect the attorney-client privilege and keep that stuff confidential to the extent you can. And in the event of any subsequent litigation, you want to say, hey, Nicole helped me out with this pay audit. It's all protected by the attorney-client privilege. But that's something that a lot of our clients are waking up to doing in view of these pay transparency laws. And a perceived risk that that litigation under the Equal Pay Act is coming. More of it is coming. And with that, I would just say we understand the realities of competition. You know, we get it that schools need to recruit, and the ER and the morale impacts that all this have. And so you want to work with your HR teams and your outside counsel to determine policies that mitigate the risk in these areas, but also comply with the law. It's not black and white. The law can say one thing, morale and recruitment are other realities.
Jason,
Yes.
this obviously is just a huge topic, and it's going to be something that we're going to have to revisit again. But I know people were hoping to get a little bit of guidance on what to provide current employees and addressing when given the pay range for a title, sort of, there's questions like, is it okay that somebody is a current employee and they're paid outside of the pay range, or talking with current employees about why one may be somebody within the same band of experience or having essentially the same duties as another employee is paid $90,000 versus somebody in the same band, let's say, is paid $130,000. So I think there's a lot. It's the two-pronged thing, and we talked a lot about posting for new hires, but what about existing employees, where I know people are concerned about how to talk about that with their employees?
And if I could kind of, I think I understand, if I understand the question, it's if we're posting for a current position, and that gets leaked among several people, and then questions start coming in. What are the talking?
It could be that, but it could also be that somebody asks you, as they're entitled to, for the range of pay for their position, and we'll say hypothetically they learn that the range is between 70 and 130,000, and they would like to know why they're only paid 80 and somebody else is paid 130. Same experience level.
Yes. And so I think that and I think what you're suggesting is, what talking points should schools be preparing for in anticipation of those questions? And I think that's obviously an individualized inquiry for the school, but I think we need to be thinking about and be ready for those questions. And it's all job related criteria. Well, so-and-so, you ask, and by the way, under the Equal Pay Act, somebody can ask about what other people are getting paid. The employer doesn't have to answer that question unless they're authorized to. And even if they are authorized to, they don't have to. You can't punish an employee for asking. If that comes up, the school needs to be prepared to explain the differences. I mean, it's really case by case, unfortunately, in that situation, Martha, but we want to be ready for the floodgates, because I agree.
It could be that it's in response to the market. I mean, we know that there are market conditions where there are some harder to find specialties, let's say.
Right. Yeah, I agree with you. And the only other thought I had was, we've gotten the question of, well, if an employee asked for a pay range in the past when we didn't have to disclose and we told them that, do we have to go back and retroactively update them? I don't think you necessarily have to go back and say, hey, you asked this question 6 months ago, now we have to give you the answer. But notifying employees of these new kind of requirements, and then maybe having either a memo, or when you update your handbook at the end of each year, there's changes totally unrelated to this that need to be updated, going into the new year. So you could work in some language, a policy, some communication, even a standalone memo about this, and then some sort of at least a kind of high level response saying we comply with all applicable federal, state, and local law. We don't make decisions based on any, protected category. Factors that may be included in some sort of pay differentiation could include education, market conditions, training, credential, experience, these objective reasons that we would then be prepared to respond. Going into too much detail beyond that, I wouldn't recommend in a policy or a memo, but be prepared to, to be able to answer those questions if they come up, at least to a certain degree.
And that is something that it'll hinge on the individual school, of course. Sometimes I agree with Nicole, maybe a policy is preemptive. On the other hand, like she suggests, the school then needs to obviously stick to it. And in these kinds of situations, some schools may want to say, I'm not going to put it out there for everybody to interpret. I want to, maybe it's going to be an internal training that I'm going to give to my HR team to manage the inquiries. So,
and having maybe one, person tasked with responding to those inquiries, so there's consistency and that person's educated. Yeah, I agree with that.
I have a question based on some of the early ones in the chat. Imagine that at my school, I want to hire a second grade assistant teacher, an 8th grade English teacher, and an AP computer science teacher. Now, I know that at my school, these categories of teachers are typically paid different amounts. Can I advertise all 3 positions with the same pay range that goes from the very bottom to the very top? Or how closely do I have to customize the pay range to the specific kind of job I'm advertising?
Nicole, do you want to take that or shall I?
Go for it, yeah.
So I think it's got to be broken up because it's any, and the law isn't really clear on what any job posting means, but it does reference job. And so my recommendation would be that you break it up. And that would be 3 separate postings with pay ranges for each.
Yeah, I think that goes to the whole transparency point of the law, that kind of core idea. And it seems like it can be subject to misinterpretation or misunderstanding if you don't break it up per job.
And then when the 3 groups of teachers get annoyed about the fact that the AP computer science teacher gets paid more than the 8th grade English teacher is expected to do this, that's not a legal problem, right? That's just a morale problem, right?
That's a morale problem, but you're going to want to have, the school is going to want to have an understanding about why we selected these pay scales for each role. But yes, that's a morale problem.
Yeah.
And like
if a school,
go ahead.
Then presumably a school is going to say, well, I need to have a system which I can report out to my folks and say, this is our reasons for and our system for deciding how much to pay people. If a school doesn't currently have that, where can they go to get help to create one?
They can, there are, and I forgive me, I forgot the name of the organization, but I know of a couple private organizations that help schools with compensation bands and salary surveys and the like. I just can't recall the private vendors, but there are resources out there, and I'm sure CAIS or Cal-ISBOA might have some of those in mind or recommended vendors. And
We'll
with
start
that,
making a list.
oh, go ahead. I'm sorry. Say that again, Deb.
I just said we'll have to start making a list.
Sounds good. And with that, it looks like we've gone over, and I really want to thank, on behalf of Fisher Phillips and Nicole and myself, this great opportunity to present. We appreciate Cal-ISBOA and CAIS inviting us. And if there are any questions that were not answered, I'm sure there were several, we can look at those after the webinar and do our best to respond in writing or by phone call if anyone has any questions. And thank you very much for having us.
Yeah.
Pay purposes. For equal pay purposes, we are talking about equal pay for substantially equal work. That's what the law is. And these positions, you would say, are different. They're different subject matter. There requires different skill set, different levels of education, etc. So you really wouldn't, from an equal pay risk perspective, considering them all together. If that makes sense, Martha.
Can I elaborate on that and say, what about schools that have been in the past paying teachers because they're really good at their job, more than teachers who do the same job, but they're just not as good at it? And that's a very hard thing to quantify when you're a school. Are those schools going to have to start paying those two teachers the same because they do the same job, even though one of them's much better at it?
Well, the short answer is no, not necessarily. I mean, so the Equal Pay Act says that if you're doing this substantially similar work, you need to pay the people the same amount. But then if unless there's a legitimate, we call it a bona fide, that's the only Latin I know. It just means like an honest, good faith reason why one teacher, the poorer performer, is getting paid less than the strong performer. And assuming that the performance evaluations are clean, that they were appropriately and objectively evaluated. Hey, Jason's not as good as Deb, and Deb is getting paid a lot more because he's not as good, and his performance reviews in these areas are they're subpar. So that would be the justification. You need to have a legitimate reason to pay people differently. Where it can become a problem is if, and this would never happen, Deb's performance evals were equally as subpar as Jason's, and they were still, she was still getting paid a lot more than I am.
I think more likely in our schools is that everybody has stellar evaluations to encourage them and make them feel that they, belong and are happy and so forth. And in fact, one is much stronger than the other. It's just not reflected in the evaluation. So it sounds like if we want to pay our stronger teachers better, we've got to get a little more brutal in our evaluation processes.
How about honest instead of brutal?
Okay, Martha,
Yes.
you're such a sweetie.
Yes. Deb, I would agree. I would agree with that, right? I mean, and that's obviously individualized, meaning case by case, because we all have situations. And that's endemic, by the way. The rosy colored performance review is endemic to a lot of employers, whether you're a school or otherwise.
Yeah.
My next question is about sharing of pay scales, because I know a lot of schools are going to say, well, I got to create a pay scale now. Has anyone got one I can borrow? And I know that with antitrust law, we have to be very careful about that. Is it okay for schools to share pay scales as long as they erase the numbers in them? Or is there some other way for that to happen? Oh, that's okay.
Nicole, do you want to handle that, or shall I?
I was just unclear. Share the pay scale, but erase the numbers. Were you thinking? So what would be shared in that point?
The categories and
the categories. Okay.
Yeah.
Yeah. Well, the thing that I was thinking was, it's going to have to be based on the actual reality of the specific situation, right? So there is some of that to keep in mind, and there's actually more of that we've been hearing about in other areas. So antitrust and competition and all that, that's something that our flags are very highly raised on. We're really tuning into that recently. So we do want to keep that in mind. And Jason, if you wanted to add anything else on that, that'd be great.
Yeah, I would just say that, I mean, I know it's a reality. We all want to know what the competition is doing. I think if we're looking at legal risk, the question might be, well, is this school relying on a tainted or flawed pay scale from another school that might, maybe that school doesn't have the buttoned up practices that your school does. So there's maybe the risk of that. The other thing is, remember, it's what your school reasonably expects to pay. And so if ultimately you're trying to get market information, then, that might not be a problem. And I gather too, that most schools aren't going to be adopting wholesale what, another school is paying. It's just a data point to consider.
And the other, I just want to, because we have a large survey that collects faculty, faculty salaries by years of experience. There's also a section in there about hypothetical pay and using various different criteria and how that's weighted at your school. But, when we look at those, we do comply with the best practices. So this is information that, these salaries are out there. It's more than 3 months old. It's being collected by a third-party provider. You are not directly sharing information with your competitors. They've been in place for the entire school year by the time you're looking at them. Certainly for admin and staff, we are collecting it and only showing, we don't show anybody's individual pay. So from that perspective, it's the safest way for you to get this information. And there is a lot of information out there already in your fingertips. I'm looking in the chat and I almost had a heart attack. Thank you so much, Ellen Failer, for asking if we were going to add different grade levels and subject matter expertise to the faculty pay data that we're collecting. And you're making me super happy that I'm retiring with that. But I will say, I think that may be getting a little granular for some schools because it will tend to reveal some individuals' pay. So we'll talk about what information would be helpful going forward, but I wouldn't expect that right away. So.
And there's a really interesting point that once you start posting your pay scales, then other people are going to see what your pay scales are. And so that's not antitrust if you're just, reading stuff.
With the law. Right. Yeah, I think there's an interesting comment about having a follow-up, maybe roundtable. Maybe you guys already do that, but I think there's so much value in sharing information about how, different organizations are kind of implementing and addressing, communicating, messaging, and then, publicizing this information.
Yeah, I think that the categories are very variable between schools. Some schools may have an explicit difference in how they pay teachers of different grade levels or how they pay teachers of different subjects. And that's not illegal. It's just something that you have to say if you're going to do it, right? And I do think that we're going to have a lot more conversations about this coming up, but it is 1:30. So I think we're going to wind up and say thank you very, very much to Jason and Nicole. And Martha, will you wind us up to end the session?
Sure. Just a reminder, we will be sending out an email to all of you. Anybody who is registered, whether they attended or not, will get an email with links to the recording and to the slide deck. And it will also contain information on how to reach out to Nicole and Jason. So all of that will be in one place. I would expect it within the next couple days. If you don't see it by then, check your junk mail. That's usually where it ends up if you don't get it in your mail. So, and again, we know that this is incredibly detailed. We know that there's still a lot of ambiguity around this topic, awaiting clarification. And Deb and I will continue to be in touch on it. And I know CAS will be doing things, we'll be doing things. We've already talked, we're going to be talking about this for a long time. So.
Thank you, everybody. It was a pleasure. We
Thank you.
appreciate it.
Thanks,
Have a good
everyone.
Thanksgiving. Bye-bye.
Bye.